Well, good morning, and a morning that we thought may never come. We're having oral arguments in person. I was introduced. We've got also on the panel, we've got Judge Rand Wallace, and since it's a very special occasion, we have Senior Judge Tom Sawalya back to sit on the bench and pass judgment on y'all's cases. We've got two cases on the docket, both criminal, and of course these days it doesn't matter. All cases get 20 minutes. We typically reserve 5 minutes for rebuttal. If the appellant wants anything different than 5 minutes, please let us know, and we'll be happy to adjust accordingly. And our first case is Alexis Colon versus State of Florida, 20-1646. And for everybody in the courtroom, which is, again, a nice thing to be able to say, please turn off any noisemakers you have, because they're guaranteed to go off at exactly the wrong time. And with that, we will go ahead and get started. Is 5 minutes for rebuttal all right with you?
Yes, Your Honor.
All right. You may proceed.
Your Honors, may it please the Court, I'm Elizabeth Fryer, and along with Mr. William Pennell and Laura Sapiro, we represent Mr. Colon, and the 5 minutes for rebuttal is perfect, Your Honor. Thank you so much. Because of time constraints, Your Honor, we're going to concentrate, it's my plan to concentrate on the first claim that has two subclaims. However, obviously, if the Court has any questions about subclaim 2, I'm happy to answer that. Otherwise, we'll just rely on the briefs for those issues. Your Honor, based on the facts and the evidence in this case, the trial court erred in failing to grant the defense motion for judgment of acquittal. Even in the light most favorable to the state failed to establish the elements of the charged offense by competent substantial evidence. In particular, in our first subclaim A, the state failed to establish the elements of penetration and union. There just simply was no evidence on that.
Ms. Fryer, I guess the testimony that was part of the trial was that there was sex. Correct?
Correct, Your Honor.
A generic term, or I guess a common term, sex. And I guess in this case, we're talking about the granting of a judgment of acquittal, which is basically taking the evidence in the case away from the jury. You would agree?
Yes.
Okay, so that would not allow the jury to apply what would be the reasonable definition or interpretation of what sex is. Is that correct?
That's correct, Your Honor, because we're talking about vernacular. We're talking about some idea of what this vague term may mean. What we find throughout is a qualifier for sex. Is it sexual intercourse? Is it oral sex? Or is it some other type of sex? The court's familiar, as we all are, of dozens of sex offenses, sex-related charges that don't require penetration. And even when the sexual battery statute, oral sex is one of the options on there. And this isn't a unique position that I've taken. This court's taken that position in JWC. In JWC, there was a child victim in there who testified based on digital penetration that the defendant, quote, played with her privates. The argument of the state in that case was, well, this is the vernacular of a child. That's what a child would say. But this court said that's not sufficient. This is a serious charge and it needs some specificity. This isn't a charge. The history of this case is important, too, in terms of charging decisions that the state made throughout. Initially, this was charged as a sexual battery on a physically incapacitated individual. What happened right before trial is the state changed their theory. They changed their theory and they said this is just a simple consent issue. So what's required from that is evidence of the offense. The state has the opportunity to make a determination about how they're going to prove their case. But what they are required to do under the Zwick decision in this court is that they have a defendant's entitled to have the charge against him proved substantially as alleged in the indictment.
What was the evidence, the arguable evidence that there was consent given, and what was that evidence before the jury in this trial?
So that's a sub B, Your Honor. That's our sub B claim. So the evidence in there is a controlled call where Mr. Colon states, you called me into the room. This is a couple with history. A history of sexual interactions, something short of a formal romantic relationship.
There was a break in that romantic relationship that romantic relationship ended, that evidence was before this jury. Is that correct?
That's correct, but Your Honor, this wasn't portrayed as a romantic relationship. This was portrayed as, AE in this case described it as friends with benefits. This was a kind of an amorphous relationship that sometimes included sex acts. So in this particular case, there was evidence that those sex acts had ceased at some point, but there was also evidence that Mr. Colon was called into the room at the night in question. One thing led to another, and some amorphous...
Well, that's taking everything in the light most favorable to him. Is that the standard we use?
Certainly not, Your Honor, but that's just the facts in evidence here.
The facts and evidence, I mean, if you kind of look at things, and again, the controlled call is an awful lot of it, but it goes from some of the text and everything else saying, I took advantage of you. That can be perhaps ambiguous. You were delirious. That's not that ambiguous in terms of whether somebody's awake and able to consent. You were half conscious and half unconscious, Mr. Colon says. Once again, that's not exactly describing somebody who's in good shape to consent to having sex, especially when he says he knew she didn't want to have it. And finally, you get to the point of, and I think this, you explain this one away and you get a gold star. I figured you would want to know we had sex that night. Now, how do you square that up with we had consensual sex?
Well, we have an issue here, and what we have is a decision to charge this. The state made a determination right before jury selection to not charge this as physically helpless. That wasn't an issue that was before the jury in terms of an element of the offense.
Well, I understand, but in terms of consent, if somebody was delirious, half conscious, half unconscious, and apparently, again, best case for him, he says, we were doing it, whatever the it is, but having sex, and you passed out halfway through, so I stopped. You know, this is not somebody who's fully awake and all the rest of it. And when it comes down to saying, I had to tell you we had sex, I figured you'd want to know we had sex. I mean, I just really don't see how that squares up with being able to give consent at the time.
So, Your Honors, I would point to the decisions in this case, Bullington, we have Coley, and what these cases say are just because an individual is intoxicated doesn't mean that they didn't start with consent.
No, I understand that. I get that part of it, but the Cooley case talks about intoxication leading to reduced inhibitions, poor judgment, things like that, not you're passed out.
Bullington states that an individual, the mere fact that defendant's sex partner may have passed out for a period of time was not sufficient to show that they were physically helpless to resist. So we do have some case law for that. That's not
Consent. That's the physically helpless aspect.
correct, but the argument I'm guessing from the state is somehow they wanted to have their cake and eat it too, which is not have to fully establish the physically helpless, but to argue and convict on physically helpless. They made a charging decision on that. And this defendant was entitled to the opportunity to have all of the elements that were required established, and that didn't happen here. There's no evidence of penetration. There's no evidence of union. This wasn't a case that relied on a physically helpless theory of prosecution. Certainly not in the charging document, definitely not in the jury instructions. So when we have what is so fundamentally flawed, so substantially lacking in physical evidence, in DNA, in forensics, in any adaptation of the word intercourse by anyone, Miss A.E., she stated in this, the question to her was the interpretation of sex. I want to be really clear on this point because this part right here is, I think, where things get sideways in terms of sex and sexual intercourse. The question to Miss A.E. was this: okay, sex, what does that mean to you? This is page 238 and 239. What does the term sex mean to you specifically when he says it? And she says intercourse. At no point does Mr. Colon adopt this. At no point does she give any indication that this is a shared definition. At no point does she indicate that they have a historical agreement about what this means. This is merely her own interpretation of the opinion. But what's accompanying that? Literally nothing. We have a situation here where there's no physical evidence. She doesn't even describe the next day any sensation of having had penetrative sex. There's no physical indication of it. There's no witnesses. There's no statement. There's melodramatic apologies in what appears to be a fraught and immature relationship. There's a year later, there's a report by her. They continue to live together. But there's no physical indication of intercourse
What
in
does
any
the
way.
word violated mean to you?
It could be trust. It could be respect. It could be honor. It could be any number of things. But what he did.
So you're making the argument that the word violated when used by the victim after all of this happened was purely emotional?
I don't know. I don't know. But that's the problem. Something happened. Something. Just like in JWC, something happened.
So the word sex and the word violated for you still leaves reasonable doubt.
Not just reasonable doubt. It's beyond that. It's so ambiguous and vague. We can't fill in those blanks. This isn't horseshoes and hand grenades where we can get kind of close. This is life and liberty. So if the state has the burden to establish each and every element, we're going to require that. So it was their burden. They could have charged this anyway. They decided to not go with physically helpless. Miss AE has stated that she has memories of bits and pieces. She doesn't really remember what happened, but that doesn't negate necessarily consent in the way they charged. They held themselves to the higher burden of establishing each and every element of this offense, and they just simply failed to do that.
What is your strongest argument? Is it the consent issue or the issue that they didn't establish that they had intercourse?
They did not establish that they had intercourse, Your Honor. I think that's the stronger issue here because we can't get past that. There just simply isn't evidence of that. There isn't any supporting evidence of that. There isn't any adoption of penetration or union by the client. There's a vague term that we use very broadly here. Sex has a legal definition. Sexual intercourse means something very specific. Oral sex means something else. Union means something else. This is court. This isn't just getting it kind of close. This is a young man who got 7 years in prison. So we don't vaguely describe these terms. This is a state's burden. It's a heavy lift, and it should be. The stakes are very, very high.
So the jury is to infer that he was so remorseful, he called, he felt such guilt simply by doing what to her then?
That's the question. Something happened.
Isn't the jury entitled to make reasonable inferences from the evidence and the testimony, and we draw all the inferences and presumptions in favor of the state when we're talking about emotion like this?
Absolutely.
So isn't the jury entitled to infer that, he even told the appellant's friend that he got on top of her and had sex with her?
He did not say that he got on top of her and had sex with her to the
He
friend.
said that he had sex with her and that he got on top of her. And then she didn't want to hear anymore, so she kind of cut him off, I think.
Your Honor, just for record
What
purposes.
is the jury supposed to infer from all that? I mean, he was so remorseful for doing really nothing to her?
So, Your Honor, I just want to clarify in terms of the statement that Mr. Colon made that was attributed to him by a friend and came into evidence, is that he stated that he got on top of her.
Yeah.
That was it. He didn't say he had sex with her. He didn't say he had sexual intercourse with her.
He had sex with her from the very beginning. You're saying sex could mean different things, right? Isn't that what he said? He had sex with her.
Sex does mean different things, Your Honor. In this courtroom, there have been arguments, including sex offenses, where a person was alone in a room. Sex does mean different things. The qualifier matters. It was charged in a very specific way. So vague sex isn't enough to get at the charged offense here.
But to describe something other than sexual intercourse, in your brief, and typically people have to add a word to sex, oral sex, anal sex, this, that, and the other kind, non-penetrative sex. Sex according to the victim, meant sexual intercourse. And I understand that nobody asked Cologne what he meant by sex. But again, isn't the jury entitled to use the normal, everyday meaning of that word?
The problem with the normal, everyday meaning of that word isn't clear what that word is. Even in the sexual battery, even in that statute, one of the options is oral sex. Even in our own, we're in court now. This is the vernacular issue was taken off the table in JWC. Also in Hicks, when the young man said that he put his penis behind him, we decided that's unclear. We're not going to fill in those blanks. The state is required to have the evidence, to put the evidence down as they allege
The
it.
defendants in those two cases admit they had sex with the victim?
Not that I'm aware of.
That's kind of a big deal, isn't it?
I suppose the issue here is what does sex mean?
Yeah.
That wasn't defined for the jury except for the penetrative and union. That wasn't established here. And so this isn't a thing where we're going to be kind of making inferences. As I understand it, the law as it's laid out doesn't allow that. I know I only have 5 minutes, Your Honor.
Okay.
Thank you.
May it please the court, I'm Carmen Corrente, representing the state of Florida. As a matter for the record, my notes, and of course I don't have the record in front of me with a laptop up here, but there was a discussion about consent by the victim as in conversation with appellant, where they pointed out that the defendant used the word sex, and when the victim used the word sex, they were talking about your normal sex, just like we have been discussing now. That's on page 238, 239 that I have in my notes. I have been known to misinterpret sometimes what an inference can be made from something, but that's what I have. And I believe along that vein, there were so many different terms used, so many points where her nightmare to start with was that he was on top of her. His statement voluntarily to her friend was, I went in there and I got on top of her. His statements that he had sex, at some point he called it sex, I believe, in one of those long, the telephone call, maybe the control call, or he discussed it as if when she said sex, he didn't say, well, we didn't have sex. We had, we did something else. And he also is the one who says, we were in the middle of it, I did it, and then when you went unconscious, I stopped because I knew he wouldn't want me to do it. So he's aware that she broke it off for 4 months. They were not intimate, and so were the sisters or the two sisters, if that's what they were, who were friends. They all knew the situation. They all knew the living conditions in there, that they were not having sex anymore. She did not love him that way.
Would you agree that your strongest evidence that you present to the jury was the fact that he felt so remorseful and that he admitted that he had sex with her? That's basically your case, isn't it? The statements that he made and the fact that he was remorseful and felt so bad about it.
It's the conversations that he had with several people, yes, his own conversations, and of course, her call to her saying that she didn't consent and that she was violated, and I took advantage of you while you were drunk.
Sex can mean a lot of different things. It can mean anal sex, vaginal sex, oral sex. Would you agree with that?
I agree. It can.
And it was never defined to the jury as to what sex meant in the jury instructions as a matter of law, what sex meant?
No, it was not. It's not. Well, I mean, in the jury instructions, but I mean, as far as in the evidence and in the testimony, it was never. She was unaware of what was done, and she admitted to that until he started making comments about what had happened, and that jived with her nightmare or dream. But the state points out that in a judgment of acquittal, we've got the cases here, a couple of cases from this court that I cited that.
Well, you would have to agree that given the broader scope of sex than just anal sex or vaginal sex, they can extend to oral sex. And the fact that he was sorry, the jury had to make some rather big inferences in coming to their decision, didn't they? From that evidence and testimony?
They made, according to the state's view, they made inferences, yes, but they're allowed to make inferences.
Yeah, they are, but I mean, these are pretty big leaps, aren't they?
Not in this case, not with the wealth of the comments from his texts and from the phone call and just from the comments that he made in person to people. He obviously was very remorseful for what he did. What he did, they never talked about, like she said at that page I quoted, that when they talked about sex, they were talking about regular sex, not anal, not oral. I don't know that there was any evidence that they ever did that. But the state would say that this was from the beginning, it boils down, very end, this was a jury question. This was not, there are cases where you say you shouldn't even rule on a JOA and grant a JOA just because the victim can't remember something. The victim laid out what she remembered and what she believed happened. The defendant's testimony, that was a huge factual controversy. And if you view all the facts in a light most favorable to the state, there is no question that there is enough evidence to support they had sexual intercourse. That's how she explained it at the page I cited. That's how they understood it. If there are no other questions, we would ask you to affirm this conviction.
All right, thank you.
Thank you.
Thank you, Your Honors. May it please the court. Just for purposes of clarity, I want to make this clear. And this state was very forthcoming about sometimes the interpretation of these things. So I just want to point the court's attention to the trial transcripts on 238 and 239. There was no testimony regarding the agreed upon term sex, meaning sexual intercourse. Instead, Miss A.E. in this case was asked what she personally thought that it meant. And there was no definition of a shared agreement about that term.
On 238, and I'm looking at lines 13 through about 16.
Yes, sir.
And this is the victim testifying. So on the call, meaning the control call, when you guys are talking about it, because you are a participant of that phone conversation with Alex, did that mean sexual intercourse? Answer, yes. So it's you guys, I will grant you it may not be the clearest. She didn't go, is that what Alex called sex? Is that what he meant by sex? But when the question is, when you guys are talking about sex on that call, are you talking about sexual intercourse? And she says yes. There's no cross on that question and answer. She is, in effect, saying we use that term to describe sexual intercourse.
Your Honor, if you go up the page a little bit, you'll find, I don't have the exact line, but it's on 238. This gets defined early on. The state asks Miss A.E., what does that mean to you? It's like the fountain case.
I understand that, but that particular question takes it to when you guys, and the only you guys that matter are the victim and the defendant, when you guys are talking about it, and they're all talking about intercourse and sex, when you guys are talking about it because you are a participant on that phone conversation with Alex, did that mean sexual intercourse? And her answer was yes.
Your Honor, I would argue that's not dispositive, and I'll point to the fountain case on that. So under the fountain case, the victim in that case testified as to union. Union was established by the testimony there. But then, when it got up to the appellate court and there was a careful review of the record, it became clear that the facts evidence did not support this legal term, union. I think this is analogous to this situation here where she's, what did it mean to you? And then this term just gets used throughout. But it doesn't relieve the state of the burden, just as in Fountain, to establish those facts. And so I hear you, this wasn't crossed thoroughly, but at the same time, if you read the entire page in context, what you learn is this is her definition, and now we're just running with it, just as in Fountain.
No, I agree with you generally speaking, and I have read the whole trial transcript, and that may be about the closest to where you get an attribution to the defendant of what he means. I agree it's not 100%. I don't know it has to be 100% to go beyond reasonable doubt that they proved it, but.
Well, when we find ourselves at the JOA, what we have to determine at that point is, has there been evidence, competent and substantial, on each element of the charged offense? And this case gets fudged a lot. It gets fudged a lot. We're not saying she was physically helpless. That's not before the jury, but she was probably physically helpless, so we're going to charge it like that in violation of the Zwick case. We are charging this very specifically as penetration and union, but you're not going to get really any evidence on that. You're going to get her opinion about what maybe somebody meant on this. And that's exactly what JOA is for. It's what judgment of acquittal is, to have that gatekeeping function so you don't get these wrongful convictions on this questionable evidence, including dream evidence that somehow is, blossoms into reality. And even in taking that never equals. The facts in that never equal to the charged offense. There's no penetration or union in that either.
At page 33 of your initial brief, you said that him crawling on top of her could have meant they were merely kissing.
Correct.
And you think he was going to blow his brains out and take pills because he went in there and they were kissing?
I don't have him before you today to explain the melodramatic nature of this lovelorn individual, but I don't think it's fair for us to attribute the overwrought, his overwrought apology, and then to say, so we're just going to say because you acted foolishly and said outlandish things that you were guilty of a sexual battery, we need elements of the offense.
You would agree that the standard is to drawing all reasonable inferences in favor of the state in a situation like this. You would agree with that, wouldn't you?
Correct, Your
Wouldn't it be
Honor.
a reasonable inference for the jury to conclude that there was intercourse and penetration from all the evidence considered, the fact that she no longer wanted to have sex with him. They had basically broken up, although they were living together. She was extremely intoxicated. He calls up. He's very remorseful. Remorseful to the point where he almost gives a complete confession. Says that he's remorseful because he had sex with her. The fact that he tells her friend that he was on top of her. All of these facts and circumstances combined, you don't think that it was reasonable to draw the inference that he had unconsensual sex with her, penetration?
No,
That would violate the statute?
not simply because it's my position here, because I represent Mr. Colon. There wasn't competent, substantial evidence of penetration. And it doesn't erase just because she had some drinks.
A judgment, motion like this, the trial judge has to decide, well, taking all the evidence together, could the jury draw a reasonable inference in favor of the state? And then he sends it to the jury, and the jury makes the decision. Isn't that what happened here?
I disagree, Your Honor. It did go to the jury, but the judge was required to make certain that each element was established. We require that competent and substantial evidence. And for the remaining arguments, we'll rely on our brief unless the court has
A lot
any
of
further
times it's
questions.
not direct evidence of an element of an offense. You have to prove it by circumstantial evidence, and you draw inferences based on the circumstantial evidence to come to a conclusion. And the question is, were the inferences reasonable in this case to send it to the jury? And it certainly seems to me that you could make that argument. It would be a valid argument, a strong argument, really.
Your Honor, in light of the JWC decision and the Hicks decision, where vernacular, agreed upon terms, was insufficient, That's the situation we have here. We know that something happened. Something absolutely happened. Something he was incredibly sorry for, something that was very upsetting to him, something he needed to talk to her about. But the what that happened is the state's burden, and they just failed that this time.
All right, thank you.
Thank you so much.